Good afternoon, everyone, and welcome. My name is Behnaz Mansouri, and I am a senior attorney with the Unemployment Law Project. The Unemployment Law Project has been around since 1984. We're the only freestanding legal aid office in the country solely dedicated to unemployment. The Unemployment Law Project provides low-cost representation and free advice and counsel to people in Washington state who have been denied unemployment benefits or whose award of benefits is being challenged. We are here today with our weekly webinar, which occurs every Monday at noon. The purpose of today's webinar is to share the latest news on unemployment benefits, to provide information about a recently filed lawsuit, and to answer any questions you may have. We'll share commonly asked questions, and I will also be monitoring the chat section in the Q&A. I'll also be providing resources as Ann gets to individual topics, so you can find those in the chat section, and I'll drop them in the Q&A section as well. I'd like to introduce our speaker today, Ann Paxton, staff attorney with the Unemployment Law Project.
Thank you, Behnaz. Now we're waiting for John Tierpak, our executive director. Oh, here he is. Well, I'm going to come back to you in just a second to see the first topic on our agenda today, which is the lawsuit. And we've gotten a lot of questions about a petition for writ of mandamus that we filed a couple of weeks ago with the state Supreme Court. And John can give you a little bit of background on that and what it's for.
All right. Good afternoon, everyone. So more specifically, it was filed by the Sheridan Law Firm in Seattle. So Unemployment Law Project is listed as a party, as an interested party, as well as a couple claimants. But the impact of this will affect anyone with a claim now who is waiting. It's not a class action suit, and it is designed to get the state Supreme Court to follow the law and to process claims in a timely manner and make payments in a timely manner. They have been using the fraud investigation as an excuse to hold up payments, and even people who have provided ID are still waiting. People who had problems in March, problems in May since they asked for IDs. So again, it's not a class action suit. There's no damages involved. It's just to get the state to do their job and process claims in a timely manner. They've had an opportunity since March, knowing what the unemployment rate is and what the new rules would be to properly staff up and hire enough people to process claims. So it's not often done because most lawsuits will go through a state court and then the Court of Appeals and Supreme Court. But a writ to ask, a petition for a writ to ask a state agency or to order a state agency to follow the law and do their job is something that the Supreme Court can do. It was filed on June 5th, and there was a motion to accelerate the case, to expedite the case, to get the court to ask the court to rule on this quickly due to the great need for people out there, people who are on the verge of homelessness. Some people are homeless already, by the way, over this, to get them to move ahead. So I don't know when the court's going to rule. It'll be in July, we expect, whether to accelerate it or not. And people have asked our office, we've gotten hundreds of calls a week with people who've been having trouble since, March, April, and May in terms of getting benefits. And people ask, can I sign on? Can I be part of it? And so again, it's not a class action, but the law firm, the Sheridan Law Firm, has asked us if we could gather witness statements. They're sworn written declarations from people who are still waiting for benefits or who were getting them and are not cut off, or people who've requested hearings and are still waiting weeks or months. So you can contact the Unemployment Law Project, either our office in Seattle or Spokane, if you do want to make a statement. And to make it clear, you would not be a client. You would not be a party to the suit, but you would be a witness to support the suit by giving your personal story of what you've been through, how long you've been waiting, and what the harm that it has caused you. So I'd welcome people if they want to contact me. Like if someone wants to do this, I can put my name and my email address, and you can email me your name and your phone number, and I could add it to the list because we have law students and attorneys working on this in our Seattle and Spokane office who are gathering these witness statements, and they would interview you and write up the statement, and then you would review it to make sure it was correct and then sign it. So I'm going to add my name and email, and I would welcome, there it is, people to contact.
Thank you, John. I just want to mention as well that the Northwest Justice Project, shortly after our suit was filed, the Sheridan Law Group's firm's suit was filed, also filed a complaint in Thurston County Superior Court against the Employment Security Department on the grounds of lack of due process for the way in which they've been handling claims, and in particular appeals, which have been in a kind of tortured process where people are not even sure that they have a question that can be appealed. It's not clear from the notice. So there are quite a lot of problems, as I'm sure many people listening today can verify. So there's at least 2 suits underway, and there's much more to be seen as those progress. And if you have any questions about these along the way, Benas can decide whether to, interrupt us, or if you want to just save them for the end, that would be fine as well. So what we've been trying to do is go through some questions that we're getting fairly commonly and answer those as best we can, and then turn it over to audience questions to see what's being left out. And the fact that we have twice as many participants today is a signal to me that or at least confirms what my impression is, that the current requirements for applying for benefits have gotten more confusing than they were even a few months ago. And so one of the major points of confusion right now is how much longer is the job search requirement suspended? So since March, the state has temporarily suspended the requirement that you be actively seeking work. That is, looking at 3 separate employers a week for specific jobs, keeping track of those, making them available to the Employment Security Department. That's been suspended because of the obvious fact to everyone that there's so many closures, there's so many employers who are not hiring, and there are also claimants, the public in general, the working public, has a lot of difficulty getting to jobs and getting to interviews and so on. So that's been suspended. It was extended until July 1st, and that is where it is due to expire. As of July 1st, the requirement is that you must make 3 job searches a week, keep track of them in a log, make them available to ESD. And I want to mention that the Employment Security Department has asked the legislature to further extend the job search suspension in order to help workers and claimants. But time is rapidly running out, and it doesn't look like that's going to be suspended, but they can always surprise us. So there's a possibility it may be further extended. For now, the requirement is, as of July 1, you must conduct an active job search, 3 contacts a week.
Anne?
I
Yes.
would like to add something, because we've been getting a lot of calls about, like, this is crazy, no one's hiring in my area, it's ridiculous, why it's a waste of time. Yes, a lot of government rules are ridiculous and lead to a waste of time. However, it's not too hard to email a resume or to fill out an online application for work that you're suited for, that you would be able to accept or to do, even if you think someone isn't hiring. So
Mhm.
it's a search for 3 suitable jobs for you. So don't apply for anything far away. Don't apply for anything that's risky or dangerous. Or if you have health issues or family members have health issues, don't put yourself in any risk. If your doctor thinks you should only do online jobs or from home, don't only apply for those jobs. And if you don't get them, you don't get them. But then unemployment office won't be able to come back at you and claim that you failed to follow the rules and that you'd have to pay all the money back. So if you're unemployed, you have some time during the week, and who knows, maybe some of these job contacts will lead to something that will take you to a better place. That happens. But I've been hearing from a lot of people who really feel that either there are no jobs or realistic hiring, or the jobs that are there are very unsafe for them, and no one should apply for or accept a job that is unsafe, or something that your doctor would not approve of. And sometimes you don't find out until you actually interview. But if you refuse it at that point, if you're offered and you refuse, that would be good cause.
Okay. Benas, you had a question?
Yes, and we have a participant whose job is still on furlough status. Do they need to do the job search requirement as directed by ESD if it is in fact implemented after July 1st?
So, John, you may be better at answering this. Furlough can be different arrangements. It could be a temporary job, temporary layoff. It could also be 1 day a week, like the governor is imposing on many state employees, apparently not including ESD. There's a lot of different arrangements you can do. It sort of depends on what kind. John, do you want to comment?
Well, the reason words are used interchangeably, and sometimes they mean things that are more generic, and sometimes they're very specific. If the person is referring to standby, being on standby, if the person is on standby, whether the rule is suspended or not, or re-implemented or not, if you're on standby, and that's been in the unemployment law for years, you don't have to do a job search. If you're officially on standby, now you don't declare you're on standby. It's something that is between you and your employer. And the word is very specific in a legal sense. Some people are on standby in a general sense, meaning the employer informally says, hey, come back when you're ready, or I'll let you know when we're ready to open up, come back. Well, that's an informal standby situation, or a temporary layoff or furlough. They can get very confusing. I would, to be safe, if you have time, I think you have time to make 3 job contacts by email or online. That would probably take you a short amount of time. If there is doubt, it's better to err on the side of caution rather than deal with thousands of dollars of repayments.
Okay. Is that the answer that you need, Benas, for that question? Okay. Thank you. So next question, how long will the $600 per week be added to benefits? How long will that continue? So there has been some confusion about this as well, just because we've gotten messages that aren't quite in sync between the Department of Labor at the federal level and the Employment Security Department. It's no one's fault, it's just that the legislation was put together very fast. But anyway, the $600 was originally said to expire July 31st. In actuality, it's expiring the week ending July 25th. So that may be somewhat sooner than people are expecting. But it, in fact, is only another 4 weeks or so that it will be in place. Just to clarify, this is the pandemic unemployment compensation addition to both regular benefits and to benefits under PUA, the federal expansion of benefits under the CARES Act. So that has helped sustain a lot of claimants who have relatively low benefits, especially in other states, but in Washington as well. So we have hoped that there would be some kind of extension, that this would have to be approved by Congress, however, and the signals we're getting from that quarter are not positive. So we're not expecting that to last past the week ending July 25th.
The House passed it, but the Senate won't touch it.
Yeah. So this is probably our number one question ever since the pandemic hit, and that is, why isn't ESD answering the phone? There happens to be a particular reason this week, because starting June 24th and lasting until basically next Monday, ESD has pulled all of its personnel to aside from the phone lines in order to catch up with its backlog. What they've said is, when they've done this in the past, when they've just borne down and focused on the backlog, they've had a 90% increase in efficiency, and that may be true. Meanwhile, people are not able to get through. On the other hand, most of them weren't able to get through anyway. So we don't really know how many phone lines were being answered. As John always says, we don't hear from the people who have successful interaction with ESD. We hear from people who are having trouble. So I'm sure many people will be affected by this. It is temporary, and they're hoping it will be a way to bring some improvement to their claims load. Some people have received calls from ESD asking them to verify their identity. Are those legitimate? So we asked this specifically. This is very concerning, obviously, because if you receive a call from a number, and in fact, many of the ESD calls come from a without caller ID. I think they have fixed that as well, but in the past, that's been true. So you're getting a call from a person you can't even identify, asking about your identification information. What ESD has said is that there may have been some new hires. They've had to take on some new people, train them very fast, and the director of policy told us that some of those may have been making calls. They have stopped them, and they say that you should not answer any calls from somebody who says they're with ESD about identification. They're not making those calls now. Another issue that came up in the last couple of weeks is, and there was quite a lot of press attention to it, was the fact that some banks, led by Chase, notably by Chase Bank, had frozen some claimants' bank accounts without any warning and without allowing them to access their balances. So leaving them in even more dire situations than many of them were. And they did get a lot of press attention about this. And interestingly, Michelle Lee, one of the anchors at King 5, was in a press conference with Susie Levine, the commissioner, last week, and I asked her about this, and she said, have them contact me. So if you hear from somebody like this, because we have also heard about some of them getting reversed so that they did have access to their funds. But there has this very engaged anti-fraud effort, and we have been told that it's related to that. However, the commissioner says that shouldn't be happening. So if you need to contact the commissioner, you can do it through Michelle Lee, and maybe Behnaz, you could put this on the chat. It's MLI for Michelle Lee, MLI at king5.com, KING5.com. So since we have that specific invitation, I wanted to mention that in case anyone is affected by it, or you can refer to other people who might have experienced this really, really distressing freeze of their funds. So this has been a question that has been really unsettling for us, because since our main business is handling appeals, and in some cases we've wondered if that has been an obstacle for people who are applying for benefits under PUA. In order to receive the federally created benefits under PUA, you need to be denied regular benefits from the state. So many times people are denied and then they appeal. So we wondered, does that have some impact on their application for PUA? In order to qualify for PUA, you not only need a denial, you also need to have a COVID-related reason to be unemployed or partially unemployed. So the question was, I have appealed the denial of regular benefits. Can I still apply for PUA, or do I have to wait until the appeal is resolved? And the answer we got from Employment Security Department Policy Office is slightly complicated, but it's important because it does affect so many people. He said in situations where a claimant is affected by an indefinite denial on their regular UI claim, unemployment benefits claim, and they meet the requirements to be eligible for PUA benefits, they may be paid benefits under a PUA claim while an appeal in connection with the indefinite denial is pending. The PUA claim would not be put on hold. However, if the appeal, this is important, if the appeal results in an overturned or modified decision, which then allows benefits under regular unemployment, any weeks the claimant is eligible for payment of benefits under the unemployment claim would no longer be eligible for PUA. So those weeks originally claimed under PUA would need to be transferred to the regular UI claim if they're determined payable after the appeal determination. If the regular UI weekly benefit is lower than what was paid out of the PUA claim, this will result in an overpayment. But from what I can tell, it's not going to affect everyone, and it won't be a hugely significant amount of money. This example was what the policy director said was that such situations would likely involve claimants receiving a minimum weekly PUA benefit, which is $235. And that is higher than the minimum under regular benefits, which is it's now $188. As of July 1, it will be $201. So complicated issue, but the bottom line is you can do both. You just have to be aware that there may be some circumstances that in which you have to have an overpayment. We don't believe it would be very significant, but we can, if you are engaged in an appeal, you can call us and get some advice on that. Did you want to add anything about that, Benos?
I do, thanks, Anne. Yeah, we have a question. It looks like it's coming in a few parts from a participant, so I'll try to recapture it as best as I can. Looks like she was denied regular unemployment, and then she got an alert to apply for, she says COVID, but I'm guessing she means PUA.
Yeah.
And when she had applied, they had asked her to do 11 weekly claims at once. And when she filed them, they then said to her that her claim filings were late, but she hadn't realized that she needed to file those. And now she is experiencing a failure to reopen her claim. So I think she's stuck in limbo. Do you have any advice for her?
Unfortunately, that is pretty technical from our end, and I don't exactly know, but I do know your eligibility for PUA begins from the time that you became unemployed. So you can do backdated claims because there was just so much turmoil and so much inability for people to file their claims and get answers to their questions. This is what they've said from the beginning. So depending on when you became unemployed, it sounds like it was 11 weeks back. All I can tell you is that you should be eligible for those. The technical elements of what, how you need to actually make those claims go through the process, I don't have much information on. Can you say anything about that, John? No.
I can also add something, and I would say it might be helpful if she looks at her messages and communications from ESD. If there was ever any formal denial or any opportunity to appeal a decision that was made, you can usually find these on the second pages of the communications. They're sort of hidden at the bottom. If you see any language that says, if you disagree with this determination, you may file for an appeal, our recommendation is that you file for an appeal. And that can be as simple as a couple sentences saying you respectfully disagree with the determination, you're requesting a hearing, thank them for their time. And in 4 to 6 or 8 weeks, you should get a message back from ESD. Either they're going to resolve it in adjudication or they're going to send you a notice of hearing, in which case you'll have an opportunity to go before a judge, and the Unemployment Law Project can help you. But what I would like you to do is to check to see if you have an opportunity to appeal, because sometimes that moves your claim from just staying stagnant over to the adjudication department, which is a process of review, and these issues can sometimes be resolved in that circumstance while you're waiting for someone to reopen your claim or to get back to you. John, do you have anything you want to add?
Yes, well, the problem is even if there is a notice with an issue that should be appealed, the big problem now is that people are not getting their hearings, that we are seeing employment security sit on thousands of hearing requests. Normally, a person who files for a hearing would have that request for the hearing sent to the Office of Hearings within a few days or a week. And the hearing office would promptly schedule something in a couple weeks. But that is the usual procedure. That is the due process right that is in the law, but that is not being followed now. So if you are in a situation where you've already requested a hearing and are waiting or are just waiting on other issues, I urge you to contact your state senator, your state representatives, also Senator Cantwell, Senator Murray, Representative Jayapal, or other federal representatives, because they've been working on accelerating or elevating some claims with problems, and they need to hear what's going on. So I would contact all of them and email and call, and then if you don't hear back, wait a few days and try it again, because some people have been able to get relief of either having their claim processed or other movement on their claims with that outreach. And I put contact information in the chat.
Great.
Thank you, John.
Benos, did you have something else? Okay, we have found actually when we help people scroll through the many notifications they might have received from ESD, it's very easy to overlook something that you got that might clarify what your status is. So that is a really good recommendation, Benos. Okay, so the question, this is a bit on everybody's minds right now, and that is the question of availability, because as everyone knows, the core requirement of, one of the core requirements of unemployment benefits is that you must be available to work. And in Washington State, you must be available for full-time work. And that's been modified because of the PUA, because of the COVID pandemic, which has led to emergency state rules. And in addition, the CARES Act, which has set new rules as well. So, but the question about returning to work, revolves around what kinds of, for most people, it has to do with safety issues. And how can, under what circumstances would you be able to refuse and decline to return to your workplace based on COVID? The Employment Security Department has made it, has stated quite strongly that you must not have just a general fear of, it can't be in the form of a general fear of COVID. It has to be something more specific. One good cause could be, for refusing work, could be being at high risk of or sick with COVID-19, or taking care of a household member who is at high risk of or sick with COVID-19 when there are no telework options. And this can be tricky because I talked with one claimant who answered a question on the online claim form saying, does your employer offer telework? And she said, completely honestly, yes. But what she didn't have a room or a way to explain that her employer insisted that they must have childcare if they had children at home in order to do telework. So she personally was not able to use telework. So that was an example of where somebody fell through the cracks of the official application form. Or the claims form, and they had an exceptional situation. So we'll probably see many of those. But another one is staying home to take care of a young child because their school or daycare is closed. That's going to get complicated in the summer because it's not quite clear whether parents who had typically had an alternative form of childcare in the summer because the schools are usually closed, whether they would still be able to continue staying at home. But it sounds like in the cases where their daycare center is closed and they don't have an alternative, that they might still qualify. If they have substantially changed the job that they're coming back to, such as where the employer substantially cuts their pay or moves the job location a significant distance away, or the worksite does not meet COVID-19 safety guidelines, employees may refuse that work and continue to collect benefits. How do you know that your employer might be violating safety guidelines for the workplace? You can go to the Labor and Industries website on coronavirus prevention and get general requirements and prevention ideas for workplaces that employers are expected to follow. And let me just see if I've got this. I think I've got it here. This is a slide showing the main requirements. It's just the first 2 pages of the flyer from Labor and Industries, but it shows the general requirements. So the employer must have mandatory social distancing. They must require routine and frequent hand washing, and they must have. There's different requirements for break areas and meeting rooms. They cannot discriminate against employees based on susceptibility to COVID or anything related to COVID. And Benaz, I think you have the link to that, so you can look at that on the chat.
I just dropped that in.
Okay, good. I'm gonna go back to. Okay, and so if you check on the chat to get the link to that, and that will give you some more explanation for what will qualify you for declining the job. But it must be something specific. They've been pretty insistent about that. So,
well, one thing I would like to add is at a meeting, some Employment Security Department representatives just said, that fear alone is not enough, and it was very casually said, and I think it kind of misses a bigger picture of people and their medical issues. Many people with post-traumatic stress and other health issues, what some people might dismiss as simple fear or mild anxiety is actually a severe medical condition. And I've talked to some people who are war veterans and victims of domestic violence with post-traumatic stress, and the thought of returning to a workplace with any risk has triggered some severe medical conditions, even suicidal issues. So I think fear, it depends on what it is. I think you can use the word fear like I'm afraid I'm going to miss my favorite TV show tonight. Well, I'm afraid I'm going to, not get what I want, for, some trivial thing, but that there's real fear that's a medical issue. So whether it's for yourself, a family member, or a client of yours, that should be looked at very carefully.
Thank you. I think I skipped over the question about standby. It sounds like, okay, I just wanted to mention this because it just came up. The question is, people who are on standby, that is a temporary layoff situation, can have their job search requirements suspended. They're expected to go back to the same employer, and they don't have to search for work. And that standby status was extended to 12 weeks under the CARES Act. The question is, the problem was that at the same time, the state suspended the job search requirement. So people who were on standby wondered if they would get credit for those 12 weeks now that the job search requirement is being reinstated. And what the ESD has said is, the question was, can these applicants get credit? The policy department says no, yes, they have not lost their 12 weeks. When and if the work search requirements are reinstated, and they mentioned that they're continuing to seek extensions, so that's not out of the question yet. Workers will again be able to request standby. We will have to determine and provide in rule the number of weeks for which standby can be granted from workers and or employers. So complex question for people who aren't on standby, but it's very important for people who are, that they may be free to continue without meeting the job search requirements that would normally be set. So this is one of the frequent questions we get affecting substitute teachers and other school employees. and it is what kind of help is available for school employees who will be barred from getting benefits over the summer. And just briefly, this stems from a federal law under the Department of Labor, which prevents people who have a normally scheduled break between academic terms, such as the summer, from getting unemployment benefits during that period. It happens to be very unfair for many types of school employees, such as substitute teachers who have very few hours to qualify for benefits in the first place, may have been collecting benefits now, but are looking at a situation in the fall where they don't have much reasonable assurance, as it is called, that they'll be able to return to that job. If they do have reasonable assurance from their districts that the job will still be there more or less as it was the prior year, then they are barred from benefits. And it's a very difficult situation for many people. They're looking at not having access to benefits now, when in reality, they're just as affected by COVID as many other people who will be continuing to get benefits. So this is something that ULP is trying to work on with the help of some other of the associations of substitute teachers in the state. And we're hoping that we'll get at least some input on this issue soon. And we're trying to push for some action on the part of the governor.
And I would like to add a little bit on that, because the reason they have these rules, and of course you might have a rule that makes sense, but then when it's applied across the board, it leads to terrible results, is that if you're, let's say, a full-time professor at a university or a full-time teacher with a year-round salary, you know, I think most people would agree that unemployment would not be appropriate during summer break. But substitutes and who have other school-related jobs are kind of drawn into this net. And when you're a substitute who may only work 2 or 3 days a week if they're lucky, and then summer comes and there's no unemployment, this is a serious problem for them. And the law should be changed. But right now, the big problem is that the school districts send out these letters. If the school districts, as a policy, just quit sending out these letters, then everyone would be able to get unemployment over the summer, who are, you know, people who are substitutes or lunchroom attendants, or people who do maintenance at schools, and also part-time community college instructors as well.
Yeah, and unfortunately, the PUA has been described as the benefit of last resort for people who don't qualify for regular benefits but are affected by COVID in terms of their employment. But unfortunately, it does not apply to these school employees. So it is a really unfortunate missing piece in the coverage of people for unemployment benefits. And finally, just wanted to mention something that came through fairly recently from ESD to help people with disabilities in their filing of claims. The ESD has set up assistance on, and you can get information online. I think Benas is putting that on the chat. So there is a site you can go to find out about their equal opportunity programs and how you can get help if you have a disability with your unemployment claim. They say they have already helped several dozen people. But this is also an issue that ULP has been concerned about, because among many other things, a lot of people in general and people with disabilities lack adequate access to computers or to Wi-Fi to start with, and then they have a lot of other barriers as well. So it's an ongoing concern, but there is at least this one program underway now. So that, and just wanted to get to this page called the eligibility checker. I always mention this because it's it's a very clear description of what regular unemployment benefits, what's required to qualify for those, and what's required under COVID, under the PUA benefits under COVID. So it answers a lot of questions in a very concise way. And I think Benas has the link for that as well. There's also translations of it appearing, I've just noticed, in different languages like Maori and Tagalog. So that it's really a worthwhile chart. And these are the labor and industry. And this is a fact sheet that literally just came out today from the policy office at ESD on frequently asked questions for educational employees and employers about reasonable assurance. And I don't have a link for it. However, if you want to put my email address down there, Benaz, I can find that out after the session and get back to you if you want a copy of this. So at this point, we like to turn it over for questions. And Benaz, I think you might have some in the stack there. Oh, you're muted. You're muted.
Sorry, thanks, Ann. I was just.
It muted you again for some reason.
I think I unmuted it and then our office muted me. Okay, I'm unmuted. I'm just finishing dropping your email in for the reasonable assurance FAQ. That's now in the chat. We do have a number of questions. So a question came up that we have a participant who has a doctor's note saying they cannot return to work until a later phase. Do they have to start looking for jobs on July 1st if that's when the searching for work requirement begins?
I'll take this one, and Anne, I would want to hear what you would say. I think there's a realistic answer and maybe a more practical answer. I mean, realistically, if your doctor says don't work, or you could say, well, you can't. But a more practical solution would be to apply for jobs online and keep a record of job searches. Apply for jobs that your doctor would approve of, things you could do remotely or otherwise, and just make those 3 contacts a week. That way, in spite of the absurdity of this whole situation and the terrible rules and the bad administration of the program, it may protect you from being called on it later. Because as bad as ESD is at processing claims, they're really good at collections and overpayments. It's amazing. They might take weeks or months to process a claim, but if you have an overpayment, they're on you right away. So protect yourself, and there's a way to do it realistically. Think about what your skills are. Think about where you live. Think about, I would be happy to talk to people individually. If you want to email me, my email is in the chat, about individual circumstances and suggestions, because I think there's a way to do it. I talked to someone a while ago who is a nurse and who is able to keep working because she's a consulting nurse and is working from home. So, when I heard the word nurse, I thought, I picture a hospital, I picture a doctor's office. And so a field might have complex, opportunities in different ways to be able to look for work. And again, the job search requirement doesn't require you to get a job. It just requires you to apply for a job, get your resume or an application in there. And during periods of high unemployment, of course, it's hard to get new jobs. But if you're fulfilling the requirements, then they can't hold that against you later on.
Yes, and so if you have a doctor's note that has some parameters, like you can't do work, you can't work that involves picking up heavy objects, or you can't do various other kinds of work, that's one thing. But you, in general, for regular benefits, you do have to be available to work. That means that even if you have a disability, in order to in general to collect benefits, you have to be available for work with accommodations by the employer. That is not true under COVID, because if you have a COVID-related reason, you are not required to be available for work. But it's very kind of a narrow category. So if your doctor is referring to COVID, if you have COVID, that would make you that would free you from having to do the job search. Although it doesn't hurt to do a job search. But in general, you have to be available for full-time work, even if you have a disability, if you can look for work that would accommodate you.
Also, although if your disability requires only part-time work, that might be considered suitable work. It gets, again, these are very individual circumstances, so we're giving general information here, but I'd encourage people to contact us directly because, for example, the general rule is you have to be able and available for suitable work for you. So anything, whether it's location, disability, limitations in terms of payments, what your past pay was or what the profession pays, are all factors in what makes it suitable. And it's not a clear-cut thing, because there's always a number of factors involved. So, but I think everybody would keep that in mind. Suitable to keep that in mind, because when the pandemic started and people were calling us asking, well, I've been told I'm in an essential job. Do I have to take any job in my field? And the answer is no. If you have particular health issues or limitations, that job might be essential or that business might be open, but it is unsafe and unsuitable for you.
Yes. Thanks, John.
Thanks, John and Ann. Okay, let's, similar along those lines, we have an attendee who is a high-risk individual and has been seeing a physician. They suffer from asthma and allergies. Their doctor cannot release them to go back to work. They asked their employer for an accommodation. The employer's response was that the position was going to be eliminated and their services no longer needed. The participant is understandably shocked and wants to know what are their legal rights if they got fired under a COVID situation, although it sounds like they might not have been fired, but perhaps potentially laid off. So some clarification there would be helpful. And in either instance, are they still eligible for unemployment?
So we would want to refer the question about a civil lawsuit to Joe or one of the members of the Washington Employment Lawyers Association, because that would be a separate issue from whether the person could qualify for benefits. But in general, the general rule is if you are laid off from work, if you are unable to work for reasons that are not your fault, then you are considered unemployed and eligible for benefits. So there's very few, there's some limitations on that, but that person should generally apply for benefits and qualify. But this issue of wrongful discharge is something altogether different and would require obviously not an unemployment benefits solution. Do you want to add anything, John?
Well, I put the Washington Employment Lawyers Association website in the chat. It's a directory of employment attorneys who are on the employee side, worker side. And so there's quite a few on the list. So I would suggest people contact them for individual consultations about whether the employer action rises to the level that would be a lawsuit, and I would encourage them to do that, and maybe even get more than one consultation on that. When I first began doing unemployment law, I would have clients ask me, if they won their unemployment hearing, if they could get their job back, and I learned pretty quickly that the answer usually is no. Maybe some union members in certain circumstances, maybe something gets resolved, but in most cases, no. So unemployment is its own world, and winning an unemployment claim, it doesn't necessarily mean it's a wrongful termination under the law. It might be ethically wrong, morally wrong, but it might not be legally something that could be fought in court, in another court for damages. But I think too many people don't look into that, and if it's a good case, there are attorneys that will do it on a contingency basis.
Great, thanks, John. We have a participant who received a PPP loan. They are self-employed, and it allows for $800 a week to pay themselves. After expenses such as rent and utilities, their take home is $200. For unemployment, do they claim the 800 or do they claim the 200? My guess is they're filing under PUA.
So the rule is, PPP is rather technical, but the rule is if you're self-employed and you're applying for benefits under PUA, you can qualify. You have to estimate and report and basically rely on your 2019 reported income to estimate your net income, not what we would call gross earnings. When we get a paycheck, what's called gross earnings. That's not for self-employed. Self-employed people have to report their net earnings. So that might lead them to a somewhat lower benefit, but it would also have other benefits. So it's kind of a wash. It's difficult to estimate in some cases. How do you know what you're going to spend next month on expenses from a paycheck that you got, or a contract payment that you got this month? It's tricky, and not all of the rules have been laid out with specificity, but that is the rule, is estimated net income.
Great, thank you. Okay, we have a participant who was claiming, they are claiming a regular unemployment UI and got a final payment in May, but they have PEUC available on their account. Regular UI keeps popping up and they still keep claiming it anyways. After they filed, it showed their benefit amount the next day has gone down to 0 and the status is listed as pending. No red flags or messages saying they need to provide any documentation. Does PEUC automatically kick in? They have been pending for a month now and have not received any information from ESD. They also have a call into Senator Murray's office twice, but it's never been resolved.
This is another one of those questions I can't really answer. I know on the application for benefits that one of the first questions that comes up is, are you applying for PEUC? Even before people think they have filed for regular benefits to start with. But if they had an a claim that expired even several months back, they might be eligible for pandemic emergency unemployment compensation, PEUC. So that's the 13 weeks extra. So they're eligible for that. And we were told that did not require a separate application. It's supposed to be part of a seamless process, but I can't guarantee that. I've not experienced it myself. I don't know. And then there's another process called extended benefits, which may be added on to that later. So this is going to be an ongoing issue. And
also, we've been told conflicting things over months now about what the rules are and what's the recommended. Initially it was just one application, we'll do it and we'll figure it out. Then you have to apply for each program. So advice I've heard more recently is try to apply for any program, even if you think you may not need it or use it, as long as you provide correct information, that's good. And as far as contacting the Senator's office, there's a lot of good people, energetic staff that work at these offices. I would try calling them back or emailing them or calling another senator or representative's office. Representative Kim Schreier's office has indicated to me that they are taking calls on this. That's Kim Schreier. And then on the chat, I posted the access to the Washington State Legislature's website, where you can find your district, find your senator and your 2 representatives and email them and call them.
Okay, great. We have a couple questions about people who have been notified they have an overpayment and they need to repay. One of them is, both are disputing it, and one of them is in the queue waiting for a hearing. They filed an appeal. Will their issue go to collections, or do they need to start making repayments now?
I've heard, again, conflicting things. My understanding is that they are collecting overpayments, even though certain people at Employment Security said they were not. So I don't know what to believe, but the thing about it is, if you're fighting an overpayment, if it gets resolved in your favor, even if you paid all or some of it back, that should be refunded to you. And that's what we've seen, you know, in cases people to avoid collections. I would contact attorneys who deal in debt collection as well. The King County Bar Association has a debt clinic. If they are going to go to collections and are harassing you, but they still have people on staff doing collection actions right now, people who should be processing claims.
Great, thanks, John. I will drop some information about the King County Bar Association Debt Clinic into the chat in just a moment. We have a question about shared work. We have a participant whose hours were reduced after their employer applied for shared work and was approved. They filled out their application at the end of May. The employer faxed it in on June 1st. The claimant was told to access their account and file their weekly claims through their SAW account. After their first week, there was no claim available for them to file. They've logged on multiple times a week to leave messages asking how they can go about filing, and they've been unable to do anything. What's our advice?
Well, shared work must be applied for by the employer. There could be a lot of things that went awry with the program application. It's very hard to tell, make any guess at what the best advice is there. John, do you have any thoughts?
Shared work has always been a mystery to me because over the years, we've never had a hearing about shared work at the Unemployment Law Project. It's never been an issue because shared work came up a lot during the 2009 recession, and we were able to, you know, people called, you know, with questions about what it was, but basically people worked it out with their employer to be able to work part-time and then get a partial unemployment benefit. So it hasn't been an issue for hearings. And there's a lot of questions I'm getting now that I really don't know the answers to in terms of does shared work apply if you're in a higher income job? And even if you're reduced, like with the 1 day a week furlough, would that still qualify you for benefits? Could you be part of shared work? And then the question too, I don't know, is that if you're involved with shared work, does that get you that $600 in July or not? And I haven't been able to get a clear answer on that. But when in doubt, you know, with all these things, apply and provide correct information. I've had a lot of people call with complex questions about how much they're earning and whether their weekly earnings, now that they're going back to work, cuts them out of unemployment. And I can give them ideas about what the calculation is, you know, to kind of see generally if you're making, I mean, obviously, if you go back to work and you're making thousands of dollars a week, you are not going to, you know, qualify for unemployment. But there are a lot of people going back where it's very close of whether what the calculation would be. And the best advice is to simply claim and provide correct information of any money that you earn that week, the net, the gross amount, the amount before taxes, and it's money that was earned in that week, whether or not you were paid in that week.
Great, I think we'll have time for one more question. If anyone is stuck in adjudication status and they have no way of knowing whether ESD is receiving their information, what's the best advice we can give them?
Well,
go ahead, John.
Well, I mean, say some prayers. That's always good. And I don't, I mean, I'm, you know, it's funny, but I think you really, you know, we're very frustrated because we cannot really move these things along ourselves as the Unemployment Law Project. When you get a hearing, we can represent you in a hearing, or if you have an appeal petition, you know, after a hearing, that's something our office can work with. So I keep going back to contacting your state senator, your state representatives, the federal senators, federal representatives, contact television news, write letters to the editor of Seattle Times or Spokane or Tacoma newspapers, and also to be persistent. Go back if your state representative isn't contacting you back, try them again, because I don't know any other way to get things moving along, and getting their attention is maybe the best way.
We have noticed that we've gotten some reports of increased activity since the 2 elections have been filed. And we, either today or tomorrow, we should hear about the new target date for finishing up the backlog of claims that are now in adjudication, some 80,000 at last count. So you have a lot of company, if you have a claim in adjudication, a lot of reasons a claim can end up there. I think it's at least one benefit of the phones not being in operation is that there are more staff on it right now. So we hope there'll be more action in resolving those claims.
Great. Looks like we're at time. If anyone has any questions that haven't been answered, feel free to email our office at info@ulproject.org. I've dropped it into the chat. And we thank you for joining us this week, and we look forward to seeing you next Monday. Thanks, everyone.
Thanks, Baz.